All right. Finbar Martin once again comes through with a pretty good comment. He links to a website. This one right here, Void for Vagueness. It's written by a law professor, so that's fine. It doesn't really add anything to his case, so I'm not going to go over it. But he says that 232.1 should be void for vagueness. The void for vagueness doctrine addresses at least two connected but discrete due process concerns. First, the regulated parties should know what is required of them so they may act accordingly. Second, precision and guidance are necessary for those enforcing the law. Do not enact in arbitrary or discriminatory way. See Granite v. City of Rockford. This quote right here is taken directly from Federal Communications v. Fox. The issue in here, where the court did find that there was void for vagueness, was that the FCC was being arbitrary and capricious in the way it was enforcing certain standards. Like the F word was fine when people said it, because the FCC was telling people that it took repetitive or multiple acts of saying it in order for it to be a violation. So, like when Cher said, the F word in 2002, or Nicole Richie said the S word and the F word in 2003, Bono said the F word in 2002 or something like that. So anyway, all these things were absolutely fine when they did them, but then the FCC changed its ruling and said, even just one use of the word, of the F word, would get you fined. So the court said that that's pretty arbitrary, pretty capricious. You have to basically give notice to people of what is or isn't prohibited. And this section right here, which is right above his quote. What page is this? Section 2. They're not putting in page numbers in there. That's phenomenal. Phenomenal. Anyway, a fundamental principle in our legal system is that laws which regulate persons or entities must give fair notice of conduct that is forbidden or required. A statute which either forbids or requires the doing of an act in terms so vague that men of common intelligence must necessarily guess at its meaning and differ as to its application violates the first essential of due process law. Now, the court has no idea what men of common intelligence think or think like. The court is very far removed from men of common intelligence. They are all very, very intelligent people, and they are surrounded by very, very intelligent court clerks. And the lawyers who come in to argue these cases or present amicus briefs are very, very intelligent people. And so they have no idea what men of common intelligence think like, or can understand. So what they're really saying is that a lawyer should be able to look at this law and tell you precisely what is or isn't allowable. Or you should be able to present to a lawyer what you're planning on doing. The lawyer can then look at the statute, see whether what you're doing will or won't violate that particular statute, and tell you whether or not you'll be good or probably not good. So this case is void for vagueness because the FCC was being arbitrary and capricious in what it determined was or wasn't obscene. They did not give people guidelines on what was prohibited. Granted, which it cites, they found that this statute was not vague. This is not vague. No person while on private or public or private grounds adjacent to any building in which a school or class thereof is in session shall willfully make or assist in making of any noise or diversion which disturbs or tends to disturb the peace or good order of such school session or class thereof. So you could figure out, a lawyer could tell you basically whether or not you would be violating the statute. Are you going to be doing this while school's in session? If yes, then okay, we need to look deeper. If no, then you're probably going to be good. Is it something that the school kids are going to be able to hear or see? If no, then you're probably good. If yes, well, then we're going to have to look at it a little more. Is this something that's going to tend to disturb the kids? Like, are you going to have a poster? Are you going to be walking around with a poster that has like a fetus on it protesting abortion or something like that, and you have this poster with a picture of this fetus that's been chopped up and removed from the uterus, and it's going to be disgusting, and kids are going to be able to see out the window, and they're going to be upset or titillated or what have you. Or maybe if you want to stand on the street corner and shout "F the police," the kids may be able to hear that and, ooh, someone's saying a naughty word, ooh, and they're not able to do their classwork because they're thinking about, this scene that's carrying on outside. So a lawyer could tell you whether or not you'd be in violation of it. And this part right here is a good read. It's void for vagueness if its prohibitions are not clearly defined, et cetera, et cetera. So are the prohibitions clearly defined in 232.1? I would argue that yes, they are. Now, maybe people don't understand them, but that's not what the court's going to look at. The court's going to look at, are these clearly defined? And yes, so first thing you have to determine is whether or not they're filming for news purposes. If they're in a specific place, entrances, lobbies, foyers, corridors, and auditoriums, and if it's prohibited. If it's prohibited, you can't do it. If it's not in an entrance, lobby, foyer, or corridor, this first question doesn't apply, or first sentence doesn't apply. If it's not for news purposes, this first sentence doesn't apply. Okay, so there's three things that make that sentence apply. If there's a prohibition, if there's news purposes, or if there is the right location. If none of those apply, then you go on to the second sentence. Other photographs, any other photograph, if it's taken in a different place, if it's taken for a different purpose, then you go to section 2. And then you have to get the permission of the local postmaster or installation head. Can a police officer who comes on the scene figure out whether or not you violated this, or is he going to have to do some capricious or arbitrary figuring out whether or not any of these things are? And no, it's going to be pretty clear. First question is, are you in a entrance, lobby, foyer, corridor, or auditorium? If yes, move to step 2. Is it for news purposes? If yes, then move to step 3. Was it prohibited? If yes, and you're still doing it, then you violated it. If no, then you're good. Easy peasy lemon squeezy. If you answered no to the location, if you answered no to the for news purposes, then you move on to this section. Other photographs may be taken only with the permission of local postmaster or installation head. Not a problem. It's very easy for a police officer to figure out. If the police officer has to figure out if something is obscene, well, I don't know. He said the F word. Is that obscene? Is it not obscene? Well, it's obscene to me. Is it obscene to you? Then it would be void for vagueness, or it could be void for vagueness. And also remember, the Supreme Court has in Kakinda, US v. Kakinda, they looked at 232.1, which is not the same, but it's in 232, and it's similarly written. It's, there's lots of little ifs, ands, and ors in there. They held it, they didn't hold it wasn't void for vagueness. They didn't even address void for vagueness. So I don't think 232.1 is going to be ruled void for being vague. It's not arbitrary and capricious. It's easy to figure out whether or not your activity is prohibited. Just because you can't figure it out, I'm not trying to insult anybody here, but just because you can't figure it out, or because you think it's confusing, doesn't mean the court is going to think that the ordinary person couldn't figure it out. Because you got to remember, like these guys are in their ivory towers. They don't necessarily interact with people of average intelligence very often. I'm not trying to be rude or mean or anything like that, but their interpretation of what, I mean, if you deal with lawyers tend to be like 115-ish IQ. That's like average for lawyers. Average people are 100. Lawyers tend to average around 115, plus or minus, but typically on the plus side. If that's the type of person you're around, and if you're constantly dealing with lawyers understand the law, or they tend to. They tend to have a better grasp of the law than a layperson. That's the whole point of being a lawyer. So if a judge is constantly around people who are of above average IQ and who understand the law as a lawyer, as a professional, they're going to be their perception of what an ordinary person can or should understand is going to be skewed. But that's not really the sticky wicket. The sticky wicket is, are the prohibitions clear? Can the judge figure them out? Can a lawyer figure them out? Can a police officer figure them out? If so, then it's probably not void. I've rambled long enough. Thank you very much for the question. Happy auditing and have a good day.